We have attained the quorum. It's about time to make a start. This is the panel on constitutional affairs. So we invite the administration in, please. Item number 1, confirmation of minutes of meeting. The minutes have been made available to members. We have received no proposed amendments. Can I take the minutes as confirmed? Thank you very much. Item number 2, information papers issued since the last meeting. We have no papers since the last meeting. Item 3, items for discussion at the next meeting. Under Secretary, Mr. Lau Kong-Wah is here with us. Mr. Lau, the next meeting is scheduled for the 17th of November. There are 2 items there. Will you take us through those, please? Chairman, thank you. There are 2 items that we are ready for. The first one is the consultation paper on disqualification of candidates with unserved prison sentences and other related matters. In July this year, the government published the consultation document in this regard. For those with unserved sentence, they will be disqualified for electoral election. And we have listened to members' views. The public consultation ended on the 30th of September. We are at the present moment collecting and collating the input. As a related matter, we will look at the sentences and all the provisions relating to the disqualification from candidature at today's meeting. Later on in the agenda, we will be briefing members on this subject and listen to what members have to say. After collecting and collating members' views regarding the disqualification of persons with unserved prison sentences from holding office, we will be publishing a report, and we will be briefing members on the report of the consultation exercise. And this is the first item that we are proposing. Second, the Hong Kong SL government will be submitting the 3rd report to the UN on vide. The hearing will take place on the 23rd of October. The SLW will be leading a delegation from Hong Kong and the mainland to attend this hearing. We would like to submit a progress report to members at the next meeting. So there you are, 2 items for the next meeting. We have other members. Ms. Hannah Wong, Chairman, I support the discussion of the subject on vide. Now, this is the Constitutional Affairs panel. We've been experiencing this Occupy movement, or the Occupy Central movement, for 3 weeks, and the focus of attention is very much on the constitutional development, the car strike and so on, and everything is about how the government is going to take this forward. If we are telling the members of the public that whatever happens outside, we are not going to discuss this, then the public would be very disappointed. So, Chairman, you might wish to consider having a special meeting prior to the next meeting tomorrow. The task force, together with you, Under Secretary, will be meeting the 5 members from the HKFS. Will you at least come back to us with the details on the dialogue? Now, there is a lot of arguments against pocketing the proposal first. There are also suggestions that NPCSC decisions be retracted made on the 31st of August. And there are a lot of challenges raised regarding the NPCSC's decision. Mr. Liu Monghong published an article in the newspaper recently. Mr. James To of the DP also suggested that the government should submit a supplementary report regarding the latest on the situation to the NPCSC. I think if we shy away from all these issues, all these heated issues, and instead focus our attention on the other matters, then it would be difficult for us to be accountable. So, Chairman, either we have the item at the next meeting, or alternatively we can have a special meeting to be held on the situation for the government to brief us on the latest. We don't really want to see this to drag on. We don't really want to see this end in disaster. If we drag on, then the message to the community would be that you get this sorted out yourselves. The police on the front line are working really flat out. They're absolutely exhausted, and they are really caught in the middle. The students refuse to go home because these issues remain unresolved. Undersecretary, care to respond? Chairman, the two items, in particular the first one, there is a sense of urgency because we'd like to get this done before the next DC election. As regards constitutional reform, mentioned by Ms. Helena Wong, at the very beginning we have conducted a 5-month consultation, and different quarters of the community have given their input. And we follow the 5-step process. We've taken the first and second steps. After the NPCSC has taken the decision, the government has to mount another round of consultation, and we will be presenting a resolution to the LegCo. Now that's the third step. So what Mr. Wong said certainly will be done. There will be an opportunity for the public to engage in a discussion. So we will be engaging in extensive consultation, and this panel will have a chance to discuss it. Ms. Wong, I'm not asking when you're going to come back for the second round of consultation. Now, many people feel that the Chief Executive's report is biased and untruthful. If everybody buys this report, there wouldn't be very few people taking to the street. There wouldn't be people worried about having a riot. So if you say that we're following this path, there is no alternative, then I can't see whether there is any glimmer of hope in tomorrow's dialogue. Undersecretary, over the past couple of weeks, people are so unhappy about the distortion of public opinions in the first and second step of the process, and people are taking to the street. Undersecretary, well, Ms. Wong talked about all these issues, and there's going to be a dialogue to be held tomorrow. The whole of Hong Kong can listen and have access to this dialogue. As regards the constitutional reform, it is a constitutional arrangement. There is a 5-step process, and we have to take a step at a time and proceed accordingly. The second round of consultation, we've undertaken that this will take place in the 4th quarter, and that will not change. We would very much like to provide a platform so that people from different quarters, and indeed LegCo members, will have a chance to engage in discussion so that we can put together a resolution. Well, I think we have to impose a time limit because we haven't quite started our agenda items yet. 5 minutes each, please. Mr. Ip Kin Yuen. Chairman, I think we have to have a look at the proposal made by Ms. Helen Wong proactively, in particular the role of this panel. Should we wait until the next meeting before we talk about the issue? As representatives of the people and as a platform for communication with the administration, perhaps we should be briefed on the dialogue with the students. We should have a meeting to discuss the whole issue. And we don't have to be confined to the dialogues between the students and the government. I think we do have the obligation to have discussions covering different perspectives, and this is very much a platform to do so. With regard to constitutional reform, many people are considering the way forward. How will the Occupy movement develop? Would there be any give and take on the part of the government? I hope that the government will take into account the views expressed by people from different quarters. So the administration should take the initiative to give an account to us. Alternatively, we can pursue the matter ourselves as a panel. We should have a meeting as soon as possible. Now, we visit overseas countries, and the assemblies, the parliaments in overseas countries have meetings almost every week. If we have monthly meetings, and we simply cannot really fit in this very important item soon enough, then we're not really living up to our responsibility. So I hope that the chairman might wish to consider how this can be taken forward. Right? Well, I'd like to hear a response, Chairman. Care to respond? And Chairman, you might wish to consider whether this can be considered. Right, I'd like to hear from all the members first. Mr. Wong Ting Kwong. Mr. Yip Ko Him. Chairman, thank you. A moment ago I heard the two members mentioning the Occupy movement and some discussions on it.
However, let us clarify what we are talking about first. Some members of the public have this demand that they want something done about the NPCSC decision and also about the 2017 CE election. Well, they have their own stance, but I think there might be some distortion of public opinion in there, and I'd like to clarify this. In fact, in the NPCSC report, there is reflection of the Hong Kong situation. However, if you distort it and say it is not the Hong Kong situation, then I would say that the premise is not right. Plus, there is a proposal that we discuss the dialogue that is going to take place tomorrow. I don't think it is necessary. The dialogue tomorrow will be broadcast live. So what will be our role in it? There will be this dialogue, and members should appeal to the Occupy participants that they should take the opportunity to express their views, and we here in the Council have a constitutional responsibility. The administration is poised to take the third step, and the third step is what we should do. And I don't think we should interfere into that dialogue. I don't think there is a lot we can contribute to this dialogue. Rather, we should ask the Occupy participants to leave the sites and come back to the discussion which should go on. And if you want a discussion, you have to be rather exact and specific as to what you want to discuss. If you just want to talk about the dialogue that will take place tomorrow, I don't think we should do it at this meeting. Well, there are people who are illegally occupying the roads in order to express their views. Our panel should not be involved in that. Rather, I think since the NPCSC has made a decision, we want to know how the administration proposes to take its work forward. I think that would be in line with the terms of reference of the panel. I will take this up with the Secretary and the Undersecretary to see what arrangements can be made, and then we'll get in touch with members. Okay, if there are no other questions, we'll go into item 4 on the agenda. Disqualification of District Council members and rural representatives with unserved prison sentences from holding office. There are 2 papers, one from the administration. That's CB-2 68/14-15-01. And another one has been prepared by the LegCo Secretariat, that's CB-2 68/14-15-02. May I now invite the Undersecretary to walk us through the paper, and then members will be welcome to ask questions. Undersecretary. Thank you, Chairman. The administration has reviewed the provisions governing holding office by DC members and rural representatives who have been convicted of certain offenses or sentenced to imprisonment, and has formulated initial proposals. Through today's meeting, we'd like to introduce to members these initial proposals. As I was saying, in July 2014, the administration published the consultation paper on disqualification of candidates with unserved prison sentences and other related matters. To obtain public views on the disqualification of persons with unserved prison sentences as candidates at a LegCo election and other related matters. And in our meeting next month, we are going to report to you on the consultation results and also the way forward. We have also taken the opportunity to review the provisions that govern the eligibility to hold office by LegCo members, DC members, and RRs, because they may be similar, though not identical, considerations that apply to the provisions governing a person's eligibility to stand for election, as well as the provisions governing a person's eligibility to hold office. With regard to LegCo members, Article 79(6) of the Basic Law and Section 15 of the Legislative Council Ordinance already provide for a specific regime governing a LegCo member's eligibility to hold office if he or she is convicted and sentenced to imprisonment for 1 month or more for a criminal offense. We do not propose any change in this regard. As for DC members and RRs, the administration has considered the matter, and we are setting out our initial proposals. Now I'd like to defer to the PAS to give you an introduction using a PowerPoint. PAS? Thank you, Chairman. Elected DC members and RRs, if they are convicted of an offense after being elected, or if they are sent to prison, so they are not eligible anymore. That is not regulated by the Basic Law. But then under the DC Ordinance and also RR Election Ordinance, there are certain provisions which make specific regulation on this. According to existing legislation, DCs and RRs, after being elected, if they are convicted of an offense and are sentenced to imprisonment for more than 3 months, then they will lose their eligibility to hold office. If the term of imprisonment is 3 months or below, they will not lose their eligibility to hold office. And I'm talking about this as a general requirement covering different offenses. But then there are specified offenses because they will cause doubts as to the credibility and integrity of the convicted. So whether or not they have been sentenced to an imprisonment term, and regardless of the term of imprisonment, if DC members and RRs commit these specified offenses, they will lose their eligibility to hold office. These are offenses under the Elections, Corrupt and Illegal Conduct Ordinance, or they commit an offense against the Prevention of Bribery Ordinance, or under the Electoral Affairs Commission Ordinance. These provisions have been with us for a long time, and after reviewing them, we propose to maintain the status quo. We have also taken the opportunity to review the situation where people are waiting for an appeal to be heard. According to existing election laws, there are no specific requirements with regard to persons pending appeal. But then we have the criminal appeal rules, and there is Rule 29, which governs the delay of loss of eligibility if there is an appeal that is waiting to be heard. And then we are proposing to do the following. At magistrates' courts, as I was talking about, it is according to Rule 29, this suspension mechanism will not apply. So if an elected DC member or RR is convicted by the magistrates' courts, they will be disqualified immediately, and we are not going to wait for an appeal to be heard. But if the conviction is done at a district court or at the court of first instance, Rule 29 will apply, and there will be the postponement of disqualification until 10 days after the date of conviction, or in the event of an appeal upon the Court of Appeal's determination. Members will see that under the existing requirement, there is not the same arrangement for different levels of courts. At the magistrates' courts, or if it is an appeal to the CFA, there is not this suspension of disqualification. Plus, Rule 29 does not exactly target an election system. And if it is going to be used on an election system, in fact, we have not covered every scenario. Say, for example, if somebody is already in prison and that person cannot discharge his duties, etc., that scenario is not covered. And therefore, a more ideal way to do it is to specify some mechanism in our election laws in order to tackle the disqualification of persons pending appeal. Our proposal, therefore, is that whether or not the appeal is originating from any level of court and is going to be heard by any level of court at all, we would allow the DC members or RRs concerned to have a suspension of disqualification for the time being until the end of the statutory appeal period. In other words, if it is at the magistrates' courts, it would be 14 days or 28 days for other cases. If the person does make an appeal, and as long as there is no detention or imprisonment being served, then the appeal period will apply, and the determination by the appellate court would dictate the period of suspension of disqualification. Now, to talk about convicts, these people are already convicted, and but then they have escaped. They have broken the law, and they have escaped from the sentence, and so there is a matter of loss of trust, and so we propose that escaped convicts should lose their qualification. In fact, in both the DC Ordinance and our election ordinance, there are such provisions already, and these would cover escaped convicts who would be disqualified. But the Court of First Instance already said that under the Legislative Ordinance 39(1)(b), it is said that it is unconstitutional. So the DC Ordinance and the RR Election Ordinance, in other words, with regard to disqualification for people with unserved prison sentences, we don't know whether those provisions still apply. Therefore, we propose that all escaped convicts, disregarding the gravity of the offense or whether there is an appeal pending, these people should immediately be disqualified. We like to take the opportunity to deal with people after being elected are detained in some correctional services centers. Now, these are detention centers, training centers, drug addiction treatment centers, rehabilitation centers under the supervision of CSD and a CSD psychiatric center. People who break the law can be sent to prison, or they can be sentenced to such different types of correction institutions managed by the CSD. These caption centers are all custodial in nature, and these people also have the liberty restricted. And they also have to comply with all the requirements and regulations. Under the present ordinances, do these people have to be disqualified from holding office? That is not very certain now. And considering the first slide where we propose that if a person is sent to prison for more than 3 months and these people should be disqualified from holding office, we are proposing that after being elected, if somebody has to be detained in such CSD centers for more than 3 months, these people should be disqualified as well. And I was talking about a suspension mechanism for persons pending appeal. We are proposing the same to be done as well. But then I'd like to mention one detail in terms of implementation. Such correctional institutions actually have the shortest period of detention at 6 months. In other words, that would automatically exceed 3 months. So after being elected, if somebody has to be detained in a detention center, they should be disqualified immediately. However, if they are to be detained in detention centers, drug addiction treatment centers, rehabilitation centers, and also psychiatric centers, when they are sentenced to such centers, the court actually do not dictate the period or length of detention. And in that circumstance, we will look at the actual custodial period, and if it is extending beyond 3 months, then these people would be disqualified.
Finally, there are two corresponding amendments. In the consultation document, we mentioned that there may be people who have been convicted, but they are not person pending appeal, or they are people released under supervision. There will be disqualification of their status. If they run for office and they get elected, their appeal may be dismissed after they have been elected, or they have to serve the sentences, or if their bail has been rejected, or they have to be recalled to prison, then under these circumstances, we will do what the first slide says. All these proposals will be applicable to these kind of scenarios. This applies to the elected district councillors, and we are proposing that the same requirements should be applied to appointed and ex officio DC members as well. Thank you very much. PAS questions? Mr. Ip Kin Yuen, 7 minutes, please. Mr. Yip, please. Chairman, this is to clarify the situation to make the law much clearer. So on the whole, the proposals are considered to be appropriate. If I may find out a little bit more regarding the escaped convicts. Is there a definition for escaped convicts? I presume that there should be, under the law. What do you mean by escaped convicts? Whatever the gravity of the offense, there will be disqualification. Can you tell us the range of gravity? Please give us more information. Madam Zhong, please. Chairman, thank you. Escaped convicts, in the consultation document regarding the candidature, we do have the definition for escaped convicts. Basically, they are convicted and sentenced to death or imprisonment, and they are at large, basically. And we do have a pretty detailed definition there, like someone who is in the penal institution, that escaped from this penal institution, or someone that may be absconding bail, or someone has escaped when they're released under supervision. Dr. N. Zhang. Chairman, thank you. If I may put a question here on the first point, after election someone is convicted and sentenced to imprisonment, and there is A and B, and these will remain unchanged. A, exceeding imprisonment for a term exceeding 3 months, one would be disqualified from holding office. Now C, let me turn now to C. After election, someone has been convicted of the following 3 scenarios, then there will be disqualification from holding office. I don't quite understand here. Now, there are 3 points here. The first one is in contravention of the ECICO, Elections, Corruption, Illegal Conduct Ordinance. Second, the contravention of the EACO, and there will be a disqualification. There is another offense, Part 2 of Cap 201, the POBO, Prevention of Bribery Ordinance. It seems to me that this has nothing to do with election. Now, for the election-related offenses, one would be disqualified from holding office. But here, in relation to the POBO offense, can you elaborate on this, please? Now, let's say molesting or rape or serious offenses like this, they will be excluded from this scope. Is that right, Madam Zhong? In my presentation, I've already said that for these 3 specified offenses, they've been there in the law for some considerable time. We are of the view that these offenses will cast doubt on someone's credibility and integrity. That's why we are proposing to keep these 3 offenses. Doesn't matter how serious they are, they would be disqualified from holding office. Ms. N. Chung, Chairman. Now, someone has been elected, and before the election, there may be corruption or election-related offenses, and then they should be disqualified from holding office, and that makes sense. If someone gets the office through illegitimate means, then it makes sense. But we're talking about bribery. it may not be election related, but still it casts doubt on someone's integrity that he should be disqualified. But will there be other more serious offences that would cast doubt on someone's conduct, like rape, for example, which is far more serious as an offence than bribery? I think there ought to be some consistency there. Madam Chung? Chairman, thank you. Now for the prevention of bribery ordinance, it has a lot to do with the public office. If someone has committed bribery as a legislative member or rural representative or district councillor, if someone has committed an act of bribery, then someone would find this unacceptable. So that's why this is applicable to this situation. Right, Madam Chung, perhaps we can call upon the legal advisor. I don't think Ms. Chung has got your answer, your question. I think A has been included. Someone has been sentenced to 3 months imprisonment, and there is no replacement for the imprisonment. Now, as long as someone has been sentenced to 3 months imprisonment or more, that would be covered. What about B then? Well, for B, after election, someone has been sentenced to a term exceeding 3 months, and not exceeding 3 months, and there will not be any disqualification. Now, for serious offences, chances are these terms of imprisonment would be more than 3 months, and that would be caught by A. What about B? What would be caught by B? Well, like shoplifting or offences of a minor nature, which will not attract more sentences of more than 3 months. All right? Clear now? Still unclear? Well, he made it very clear. His enunciation is very, very clear, but I don't think the law itself is rather unclear, in particular C, bribery. I'm not saying that there is a bribery arising from the public office. There may be bribery arising from other businesses. Under Secretary, right? Let me explain further, Chairman. Ms. Jones' point regarding C. If someone has committed offence under these ordinances, then someone will be disqualified from holding office. Now, Ms. Jones is asking about other offences. Now, you mentioned the examples. If someone has committed these and been convicted and sentenced to a term of imprisonment of more than 3 months, then he or she will be disqualified from holding office. So it all depends on the offence and also the sentences that they attract. All right, it's a good idea to make this clear. Each will be given 5 minutes. C, Chairman. Doesn't matter how long the sentence is, disqualification will take place. All right, that's clear. Mr. Tony J. Chairman, thank you. If someone has been convicted and sentenced to a term of imprisonment, the dividing line is 3 months. This is inherited from history, although I don't know why 3 months as a threshold. Chairman, regarding the suspension of the disqualification, that there can be an appeal after conviction. How is it different from the existing practice? Now, previously, if you lodge an appeal, I'm not sure how many appeals there can be, maybe more than one appeal. So with this proposal, let's say that there are more than one appeal, how long will the suspension of the disqualification be? Can you give us some idea in this regard? Second, about the term of imprisonment. Are we basically talking about the conviction of Hong Kong offences, or what about offences in other jurisdictions? Third, after election, a councillor may be serving for a period of time, and this 3 months, let's say he's there for a couple of years, and he may have been convicted on a number of occasions. Are you talking about the sentences on individual basis? Let's say the sentence on each occasion is only 2.5 months. Would there be an aggregate terms of imprisonment? Madam Chong. Right, let me take the first question first. And regarding the suspension mechanism, have we assessed whether someone may be lodging an appeal after an appeal, and altogether 2 appeals, and this would take up quite a long time within his tenure of office. Now, we have indeed looked at the statistics. In 2013, we looked at the Judiciary Annual Report. Now, for cases dealt with by the CFI, appeal cases, from the submission of notice to the hearing, it is 105 days. Now, for CFI cases from the listing date to the hearing date, it is 50-odd days. Now, for CFA appeal cases from the hearing notice to the actual hearing, it is 40 days. Now, for actual hearing, from the notice through to the actual hearing, it is 97 days. So when we made the proposal, we did have regard to all these average waiting time. As regards the second question about these offences, should we look at the local offences only, or offences in other jurisdictions as well? Now, for these terms of imprisonment for more than 3 months, are we talking about local as well as other offences in other jurisdictions?
As for C, the conviction of a specified offence, you can see that those 3 ordinances are Hong Kong ordinances, and we follow the stipulations there. The third question, if the relevant district council member or the RR should be convicted of more than one offence during his tenure, but then the imprisonment every time is less than 3 months, and whether that would be taken together, well, no. We will regard each prison sentence separately. Okay, so you would also consider conviction in other countries. Have you looked at the appeal period in those countries as well? Ms. Chung, I do not have the information at hand. Will you supplement it? There may be some difficulty. Well, yes, there will be some difficulty because the jurisdictions vary and the appeal systems there would vary as well. However, if you should come into such a situation, you will have to handle it as well. Well, I believe the majority of the situations would happen in Hong Kong. The figures do show that in this session, district council members did not commit many of those offences, and we have not seen the commitment of such offences overseas. Actually, most of the situations can be subsumed under A, and we believe that can cover the majority of cases. Mr. Tony Jiang, What if an offense is committed in Macau and their system will be different from ours? Just like to clarify, if people appeal in Macau, sometimes in certain places the appeal period is very long. I just want to know more about this. Well, yes, this has not happened, but what if it should happen? And Mr. Chair has actually asked a very practical question. It seems it's true that in Macau the appeal period is quite long, so I'd like you to give some consideration to that. Mr. Raymond Chan. Thank you, Chairman. I'd also like to talk about extraterritorial jurisdictions, and two scenarios can happen if there is an offense committed. One, the presence of extradition laws. Second, the absence of extradition laws, or that there is a totally different jurisdiction altogether. But the administration is telling us that A can apply to other jurisdictions as well. In other words, if somebody is convicted and being sentenced to prison for 3 months, then this will apply as well. However, if there is a place where there is no extradition laws with us, that person can be absent from the court hearings, and no one can do anything about him. Now, I don't know very much about the mainland laws. Sometimes people can be detained for a long time without being sent for trial. And sometimes without a trial, you can be sentenced with a very heavy term. So I'm talking about very different jurisdictions. Are you sure that this should apply? And also, people define offenses differently. Say in Muslim countries, homosexuality is a very severe crime. And if indeed somebody is given a sentence, I'm not saying that I'm serving that sentence. I say I have been sentenced to a certain imprisonment term and then I abscond. Does it mean that even if I'm back in Hong Kong, I would be disqualified? Ms. Chung, to answer Mr. Chan, well, the answer is in the affirmative according to present laws, because it doesn't specify whether it is local or extraterritorial. As long as there is a prison sentence of more than 3 months, there will be disqualification. Mr. Chan. I'm talking about, say, an international court or overseas country. If C.Y. Leung is sentenced to a prison term, and even if there are no extradition arrangements between that country or jurisdiction with Hong Kong, then C.Y. Leung would also be disqualified. Is that right? Well, I don't think that is a very relevant example, because C.Y. Leung is not a counselor. No, I'm talking about this as a general principle. Mr. C.Y. Leung has been appointed by the central authorities. He can resign, or else he will not be disqualified. No, I'm talking about whether this is problematic, because you are saying that even if somebody is convicted in a foreign land where there are no extradition arrangements with Hong Kong, does it mean that that person should be automatically disqualified? Well, you have to exercise care when you are not in Hong Kong, because if you engage in behavior not allowed in that particular place, then you may also be disqualified. Undersecretary, we can certainly go back and take a look at Mr. Raymond Chan's point. You quoted an example, and you also said that the history, the culture, and the penalty system can be different from Hong Kong. Well, it will be difficult for us to do that kind of in-depth research and comparison. We can only set the imprisonment term, and we follow that regulation. If we have to do this kind of comparison for every piece of law, it may not be appropriate. Next one, Mr. Ip Kwok Him. Thank you, Chairman. I'd also like to seek an understanding into a certain issue with disqualification of DC members. Well, we have that, and you are now including rural representatives. I think Ms. Anne Chang asked this question. One, a person may have committed a criminal crime, and if the term is over 3 months, he will be disqualified, and not if otherwise. However, if you break the POBO and also ECICO, regardless of the length of sentence, even if the imprisonment term is just for 1 day, you will be disqualified. That's the present situation. And you're not proposing a review of this. There was this incident where, in filling out a form, the person filled out the wrong information with regard to his period of stay in Hong Kong, and he actually was disqualified. This is because he has broken the ECICO. I'd like to ask why you did not take the opportunity to review these specified offences, because they may vary a lot in terms of their severity. Second question. You talked about persons pending appeal. In the past, was it 10 days? Is it that you have extended it to 14 days and 28 days? Do these apply to offences under the ECICO? Is it that if people lodge an appeal, there will be an extension of 28 days? 2 questions, please. Ms. Chung. Thank you, Chairman. First question by Mr. Ip. You mentioned the ECICO, and certain offences may be minor and others more severe. There may be illegal acts which are severe, but then some offences may really be rather technical. The present stipulation is that we are targeting corrupt and illegal conduct only. Other conduct that will not be regarded as corrupt and illegal conduct under this ordinance, those have been excluded already. Secondly, persons pending appeal. If a person breaks the ECICO and is convicted, what is the appeal pending mechanism? We propose the suspension mechanism applies to such people as well. Or as to whether it should be 14 days or 28 days, it depends on the level of court meting out the conviction. If it is a case from the magistrates' courts, the period is 14 days and 28 days for other levels of courts. So the first point, is it that you have already given that some consideration? Can you give me some actual examples? You said that some kind of conduct has been excluded, but I cannot see that, and I'm really talking about technical breaches. You know, in the election process, there has to be an oath or affirmation, because you have to swear that the information you supply is accurate. But sometimes the information can be a little inaccurate. And is it that you have excluded that kind of behavior? Is that what you mean? Or if, of course, there is an act of bribery, then that is quite different. Is that the case, please? Can you give me examples of exclusion? Ms. Chung. Under the ECICO, there is a part on corrupt conduct and another part on illegal conduct. And then there is another part on election advertisement, and then yet another on election declarations or reports. So those 2 parts are quite separate from the parts on corrupt and illegal conduct. And we have also defined what is corrupt conduct or illegal conduct under the ordinance. Can you give me a written reply so we have a clear understanding, because this is quite important? Yes, I also think that the acts or conduct that have been excluded, I hope you can put that in writing, because there may be technical breaches or omissions. Next one, Mr. Wang Yukman. Thank you, Chairman. In July, when this panel discussed the consultative paper, we concentrated on LegCo, And now we also deal with district council members and rural representatives. I think it is only right that we are doing this review. I'd like to seek some figures, please. In the past, how many DC members and RRs have been disqualified? Number 2, their conviction record and the relevant sentence terms. And 3, the nature of the offenses. These may not have a direct correlation with the review, but that would be useful for our reference, so we know whether the review is in line with what we are facing. If you look at Section 24 of Cap 547, disqualification of from holding office as an elected member. Under that section, it is said that if an elected member should be sentenced to death or imprisoned in Hong Kong or otherwise, but the sentence is unserved, that person will be disqualified. But here, the imprisonment term is not defined. Even if it is for 1 day, the RR or DC member can be disqualified. In 24(1)(b), this will kick in and be effective when the court meets out the sentence. Now, if you look at the English, it says if he has not served the sentence, he will be disqualified. And under RREO in 9(1)(b), there is a similar provision. So it's not ideal at all. Under Section 24, there are 2 subsections that are contradicting one another. It says if the term is over 3 months without an option of a fine, well, the HAD has said that there have not been such cases dealt with under 24(1)(b) on unserved sentences. Still, the situation is not ideal. According to the criminal appeal rules, well, I'd like you to respond to this one, please. Just now I was stating facts, but here you are talking about the criminal appeal rules. I think there is a problem. Under Rule 29, if a DC member or RR is convicted by the magistrate's court and sentenced to imprisonment for a term exceeding 3 months, that person will be disqualified immediately. But then if it is done by the district court or the court of first instance, then that person will be disqualified 10 days after the date of conviction or in the event of an appeal upon the Court of Appeal's determination.
We don't understand why for higher courts you would deal with this more seriously than the magistrates. I don't think this should be the case. Also, it would depend on the severity of a particular case before a case is taken to a particular court. Presumably, the offences under trial by the district court would be more serious than those by the magistrate's court. For more serious offences, and you have to wait. You will allow this to be appealed against before you deal with it, and there are problems there. Also, the DOJ can control the entire prosecution. Rule 29, there can be some political considerations involved. Like myself and Leung Kwok-Hong, we will be in trouble. So the proposal here regarding maintaining the status quo for sentences for after the election has taken place. Now, for the ruling will take a long time, and the suspension mechanism will not apply to those with serving sentences. If someone doesn't get a bail, then there can be many considerations for a bail to be granted, and the appeal results may not be the consideration. So I'll let you know question. Have you got them all? Yes. Right, let me respond to Mr. Wong. The first question is about the DC members and rural representatives, whether there are any statistics about them losing their qualification. Now, for DC members, since this term, there was one DC member who was disqualified for a sentence of more than 3 months. So between 2008 and for the previous term, there were 3 DC councillors who have been disqualified because of a sentence of more than 3 months. For rural representatives, in this term, 2010 to now, there have been 4 RRs. Well, I think she's got your point. Right, over the past year and also the last term. But please don't waste any more time here. And this is rather irrelevant. I was just asking, please give us the information in writing. She has the information here. She's just responding you verbally. Well, I'm more concerned about the nature of the offences. You can give us the information in writing. Right? Please give us the information in writing and address the questions that are raised subsequently. Right? The appeal mechanism. Please refer to the PowerPoint. I agree with Mr. Wong that under the existing mechanism, it is rather incomplete because Rule 29 of the criminal appeal rules is not really designed for the election. And if this is applied to the disqualification mechanism, then it would give rise to a situation where the courts at different tiers will may or may not be able to apply Rule 29 at different tiers of the court. So we're proposing that doesn't matter the case arises from any tier of the court, we allow this suspension of disqualification mechanism, and that would address the present issue. Mr. Wong also referred to the time taken for the appeal to be listed, and it might take an awful long time, and this may not be dealt with even after the tenure of office is over. I've given them some ideas about the average waiting time earlier on at this meeting. It is against these background information that we made the proposal. The fourth question is about bail. Now, why do we allow the suspension mechanism to be triggered under Rule 29? 29 is not really designed for the election system. If we apply this to the election system, then someone who is imprisoned will not be able to discharge his duties. So when we apply the suspension mechanism, the condition is that someone is not serving any prison sentence. Right, next to Mr. Porche. I've got a couple of questions here. First of all, under the proposal, we have the specified offences under the ECICO and the EACO. There are new proposals there. Rule 29 of the criminal appeal rules may not be all that relevant. Now, these will only apply to those who is not serving a sentence. Has the administration considered that this arrangement will allow those who are convicted to make use of this to ask the court for a bail and then lodge an appeal? Now, since serving a sentence, serving an imprisonment would have such grave bearing, that in order not to strip the appellant of such important public function, the court is likely to allow bail pending appeal. Don't you think that this would be a circular arrangement such that people will be able to get bail pending appeal? Have you ever considered this possibility? Second, similar to Mr. Wong Yok Man's question, in your reply, you said that Rule 29 of criminal appeal rules are not designed for election. If I may follow up on this, for ordinary offences, why is it that for offences or for cases dealt with by the magistrates and cases dealt with by courts further up will be treated differently? Now, there is really disproportionate treatment for cases dealt with by different levels of courts. Ms. Zhong, on the first question, we said that there is a suspension mechanism allowed until the appellate court has taken the decision. We are talking about offences that I referred to in the first PowerPoint. In scenario A, we are talking about any offences. If the offence has attracted a term of imprisonment for more than 3 months, and then one would lose the qualification. The other is the specified offences to do with POBO and the ECICO. Now, under these two scenarios, if someone has been convicted and sentenced to imprisonment, and if he lodges an appeal, then we would apply this same mechanism. I think that addresses the first question. That's why we only allow the suspension mechanism to be triggered if someone is not serving a prison sentence, because when someone is doing time in jail, it will not be effective. Well, you haven't quite answered my question. You're repeating what you said earlier on. My question is, have you considered the fact that with this proposal, you are creating an important ground for the court not to enforce the sentence, and this will allow someone to be granted bail? I think you have to be specific. If this is not your intention, you have to make it very clear. With this new arrangement, the court may feel that there shouldn't be any immediate sentencing because someone will stand to lose the public office. Now, for ordinary cases, not specified offences, if the sentence is less than 3 months, the condition would be more stringent for magistrate court than the upper courts. There is an appeal period of 10 days for courts higher than the magistrate courts. Ms. Zhong? Rule 29 of the criminal appeal rules, how is it relevant to the election system? Members have spotted all these problems. Now, we are proposing that whether we're talking about magistracies or district courts or whatever, we are proposing that this suspension mechanism will apply. Mr. J. Now, this will not apply for ordinary offences that attract a sentence of less than 3 months. You're basically targeting at the election-related offences. Now, if this is an offence and not within this scope, but then the existing law will apply. Is that right? And there is the disproportionality there. Right, Madam Lee, from the DOJ, please, if I may, Chairman. Our proposal is that for a term of imprisonment of 3 months or less, there will not be any stripping of the status. I think that addresses Mr. J's concern. Second, you question why the existing mechanism only applies to the CFI cases in the district courts, but not the magistracies. That's because the criminal appeal rules apply to cases which are appealed to the appellate courts. If a case is decided at the magistracy level, then the criminal appeal rules will not apply, because this is not within the mechanism. That's why we have spotted this particular problem, hence the proposal here. Mr. Chair talked about the bail. I appreciate Mr. Chair's concerns and misgivings here, and we are prepared to consider this further. Now, when a case is appealed against, there is no presumption of a bail. Now, at the there is a presumption of innocence at the first trial, and the court would tend to grant bail unless that there are very strong reasons against it. After the first trial, there will not be any presumption, and there will not be any presumption of an automatic bail. So, according to the courts, that they do not look at the merits of the appeal cases alone. They will have regard to other factors, but the merit of the case will certainly be taken into account for sure.
In the least, there should be a reasonably arguable case in law. Yes. Can I use 1 more minute? Because I think this is a crucial issue. I fully understand that after conviction, there is no presumption. However, after conviction, very often, people can be put on bail pending appeal. Generally, there has to be an arguable cause of appeal, and very often the sentence term is very short, so short that the person should not have to serve it before appeal. And now the proposal is that if you do not allow bail pending appeal, then the person's public office would automatically be lost. Can you consider that implied cause for the benefit of the persons concerned? Ms. Lee, I thank Ms. Chair for this point. We will go back and consider it. Under existing laws, if you are sentenced to a certain term, then your qualification as candidacy will be lost and you will be disqualified from holding office after election. But it seems case law doesn't tell us that that has been considered. All right. Any other questions? If not, I'd like to ask the administration to take back the questions asked and do follow up after the meeting. Let's get to the next agenda item. Item 5. voter registration 2014. From the administration, we have Mr. Freely Chan K and his team. Can we invite them to come in? We welcome the PAS for Constitutional and Mainland Affairs, Mr. Freely Chan K, and Acting Chief Electoral Officer, Ms. Candy Ma from Registration and Electoral Office, and also Mr. Sham Nam Long, Deputy Chief Electoral Officer from REO. We've got two papers which have been circulated to members. One CB bracket 268/14 to 15 bracket 03. That's a paper from the administration, and then another one bracket 04 has been prepared by the Secretariat. Is it that Mr. Chang, the PAS, is it that you would walk us through the paper and then the floor will be open for questions? Yes, Chairman. I will walk you through the paper, and then the Chief Electoral Officer can give you more details. In March, members discussed voter registration, and at that time, we promised that we will come back to report to the panel the latest statistical figures for VR and also the checking measures taken in the 2014 voter registration cycle. Next year is the year for District Council elections, and I will be talking about how we prepare for that registration. The administration has always placed a lot of importance on the integrity, transparency and openness of the electoral system. In 2015, we'll have district councils, and for that cycle, we'll continue to do checking measures and also conduct inquiries. In terms of accuracy of the voters register, we also have to be mindful about the inconvenience that could be caused to voters if we conduct the checking measures, because that might dampen the desire to get registered, and we have to strike a balance between the two. If there is evidence to show that there is a false reporting of particulars, the REO, as usual, will refer the cases to enforcement agencies for investigation. The integrity of the VR system relies very much on the accuracy of the information therein. We make use of different channels to do publicity to encourage people to get registered as voters. And what is important is also to update and change their particulars if there is a change. Next year, we're going to prepare for district council elections. We have already set up an interdepartmental working group to take care of publicity that has to be conducted next year. Can I now defer to the CEO to take you through the statistical figures in the paper, and we will be happy to take questions. Ms. Ma. Thank you, Chairman. This paper seeks to brief members on the key statistics relating to the 2014 final register of electors and the checking measures taken in the 2014 voter registration cycle, as well as the preparation for the 2015 VR cycle. In July, the REO sent out the final register for public inspection. There are about 3.5 million GC registered electors. Compared to 2013, there has been an increase of about 36,000 electors. In the 2014 final register, or FR, with regard to the functional constituencies, there have been 232,700, or a drop of about 5,300 electors. And for DC, second FC, there is about 3.25 million, or 31,000 more than last year. With regard to the age groups, we are aware that from 18 to 30 years there is a lower registration level than other age groups. And that is why we have been encouraging more young people who are eligible to get registered. We make use of social media and websites in order to send out the message to young people to encourage them to discharge their responsibility as responsible citizens. From 2007, it is 50.7% for this age group, but it has risen to about 60% in the 2014 cycle. We will target this particular group in the next cycle in order to encourage them to get registered. To make sure that there is accuracy of information, the REO in the 2014 cycle has continued to take different checking measures, and we have sent out 24,000 inquiry letters. About 14,000 did not respond to the inquiries. They have not updated or confirmed their residential addresses, and so they have been removed. Such checking measures will be continued for the 2015 cycle. With regard to the 2015 cycle, the deadline will be the 2nd of July 2015, that is for applications, and those who are eligible should make the application before that date in order to be included in the FR to be published in September 2015 so that they can vote in the DC election in 2015. In fact, those who are eligible can do so between now and the 2nd of July 2015, so you don't have to run the risk of missing the opportunity if you wait too long. Those who are registered, if they want to change any particulars, especially residential addresses, they have to do it before the 25th of August 2015. Information should reach the REO by that date so that the updated information can be issued as part of the FR to be published in September next year. And also on the 1st of September, the REO has launched the Online Voter Information Inquiry System, or OVs. This is another convenient channel for electors to check their registered information online. If it is found that their information has not been updated, say if they have moved house and they have not informed the REO, then they can make a timely application for change of particulars. According to the amendment bill passed by July by the Legislative Council, if members of the public would like to make any appeals or objections, there has been an extension to 14 days. Just like in 2015, the provisional register has to be issued by the 1st of August. And so the deadline for making objections or claims would be the 25th of August. So there would be more time for electors to take remedial measures in order to protect their election rights. And also the REO will make use of the extra time to do more publicity and to appeal to electors that they have new particulars that they should let the REO as soon as possible. And those who are in the omissions list, they should also take action as soon as possible. By the deadline, they should make claims or objections or apply to change their particulars. It is an important right of citizens to get registered and to vote in an election. 2015 will be the year for district council elections. We have already set up a cross-departmental working group, including ICACHAD, RTHK, and a few other departments, in order to coordinate the publicity of the 2015 election. We will follow the example of previous elections in order to prepare the work plan for the new election. For example, to encourage young people who are eligible to come forward and get registered. We will also have targeted publicity to allow electors to understand that if there are changes in the particulars, they should discharge their responsibility and respond to the REO. At the beginning of next year, at a panel of this meeting, we'll be able to give you the details for that registration cycle. We welcome questions from members. 4 members have raised their hands, and I give you the order. Regina Ip, KK Fong, Felix Chung, Ann Chang, and Ng Liang Sing, 5 minutes each. Regina Ip. Thank you, Chairman. I'd like to thank the administration for providing the latest figures on elector registration, especially with regard to age group and gender. In September, the New People's Party paid a visit to Beijing, and you see a lot of Hong Kong People's Association in Beijing, and they had tea with us, and they raised one common issue, and that is there are tens of thousands of Hong Kong people working on the mainland. They are there for the better part of the week, but they come back on the weekend because the families are in Hong Kong. They should be eligible as voters. They are ordinarily resident in Hong Kong. They're also permanent residents. So is there a way for our officers on the mainland where there are 5 to accept their votes? Because in overseas countries, they allow people who are outside the country to send mail in order to cast a vote. Chairman, this is a policy issue. We understand that there are people working on the mainland who would like to be able to vote outside Hong Kong. However, when we consider this policy, we have to be mindful about fairness. Those people who are ordinarily resident in Hong Kong but nevertheless work outside Hong Kong, these people are not only on the mainland, but they are scattered all over the world. There may be a resource implication, and we don't have this network of overseas voting stations. We still very much hope that they can come back to Hong Kong to vote on election day. If we have to follow the example of other countries where there are measures to facilitate people living outside that country, we may be talking about a huge network which will be resource intensive. And some other countries may also allow early voting. That is quite complicated as well. If this is allowed, what should we do with the votes or ballot papers collected? And should these people have to apply beforehand for early voting? This is going to be very complicated as a policy. So now we have not come to a view as to implementing early voting or overseas voting. Well, I don't think it's as really complicated because other people are doing it. Hong Kong is an SAR. Of course, you are not a country and you may not have consulates all over the world. And where it is still expensive to keep an office, I think Hong Kong has done away with the consulates. So we should not discriminate against Hong Kong people who are overseas. Many overseas Hong Kong people have an Hong Kong ID card, but they have left Hong Kong for a long time. They may come back only when there are $6,000 waiting for them. But they are quite a different batch from those working on the mainland. They come back every week or twice a week. I think you should have separate treatment for them. In fact, they have mentioned to you many, many times, and they were telling us that you used these specious excuses to fend them off. Mr. Zhang, we understand that there are a batch of Hong Kong people working on the mainland who have this aspiration that they should be able to vote outside Hong Kong on polling day.
But we have to consider the fairness of the policy. Will there be other groups of people who demand the same right? It can be a terribly complicated issue. Now, we have to prove that someone is ordinarily resident in Hong Kong. We need to have pre-registration to prove this particular status. Under the law, we have to consider the individual circumstances to consider whether someone is ordinarily resident in Hong Kong and whether someone has maintained the connection with Hong Kong. Now, it would be easier for people who are flying back and forth, but there may be people who have left Hong Kong for some considerable time and they are in Hong Kong only on a temporary basis. We have to consider whether they are ordinarily resident in Hong Kong. There will be operational problems. Mr. KK Fong, Appendix II, if I may put some questions there. You check the multiple surnames registered to one flat, 15,000, and 1,000 or so have been taken out. In other words, 12,000 also are still outstanding. Will you be following up on those? And item 5, the buildings that have been demolished or about to be demolished, 658. You have written to 406, 300 or so have been taken out. Does it mean there are 200 that are still outstanding? How are you going to deal with them? Why is it that they are still left hanging? Also, the housing department, the 39,000, and they have not been taken out. Is it the case that after inquiry there is nothing wrong with them, or you're not following up on them? The last one, many people registered to the same address. Note 3 says that 115 have been followed up. Is it true that they have found the information and there are no problems with them? What about those who have not responded? Have they been taken out? So please, I appreciate some clarification. Madam Ma. After the inquiry letters have been issued, we ask the voters to give us the confirmation of their addresses and tell us whether there is an updating that would be needed. If they fail to give us the confirmation, they will be struck off. Can you go over them one by one? There may be different reasons for different items. Can you go over them one by one? Mr. Shum, Chairman. Now, for one surname registered to many households, we have issued the inquiry letters. We asked them to confirm and update the residential address. Some failed to respond to the REO's inquiries. 2,557 letters have been issued. You don't have to read from the paper. Please answer the question. I'm running out of time. I've got 5-minute limitation. After the inquiry letters, we group them into the inquiry procedure, and some failed to respond to our inquiries, and they have been struck off. 1,200 failed to respond, and they have been struck off in the 2013. Well, you're not answering my question. You're reading out from the paper. I can read myself. What was your question again, please? Now, 15,000 people have been identified. 2,005 have been struck off. What about the remaining 1,500? Why don't you conduct further inquiry? Now, the demolition, 400 have been issued. What about the remaining 200? Why did you follow up on them? Right, we have issued the inquiry letters, and some responded to us to confirm their addresses. It is only for those that failed to respond that we issued the inquiry letters. Now, we will first issue the inquiry letters. If they fail to respond, then we'll strike them off. There will be a 2-step process there. We'll speak into the mic. Let me explain further. Members probably remember that when we introduced the inquiry letter process, there are 2 layers there. Now, if we send the registered post to start with, the voters might get some misunderstanding. So we will issue the first letter by ordinary mail. And if they respond, there is no need for us to take the next step. Now, Mr. Fong talked about the 15,000 cases. We issued letters to the 15,000, and there are some of them that require the second step follow-up. And if it is 1,250 that fail to respond. Now, for the housing department, 39,000 letters have been issued, and none of them have been struck off. Are there any problems with this number? well, the Housing Department verified the information, and the information was verified to be correct, and we issued the notices to the voters to update the residential address, and there was no need for us to issue further letters. We have written to them to confirm the residential addresses. Right, the paper was issued by the Secretariat and not the government paper. Right, should have been issued to them as well. Mr. Felix Chung, for the functional constituencies 2014 new registration, 600 or so voters. 5,300 have been removed. In what sectors did we see more the increases or the decreases? Shouldn't more be done to encourage people to register themselves as voters? Take my constituency, the garment sector, for instance. There are 13,000 eligible voters, but only less than 3,000 registered themselves. About 10,000 of them failed to register. Shouldn't the government do more to encourage registration as voters? I understand that the second consultation exercise would float the possibility of broadening the franchise of the FC constituencies. If the franchise is broadened for the election committee, then will the constituency size of the traditional functional constituencies be broadened as well? Mr. Cheng, right? Regarding the electoral base of the traditional functional constituencies, under the NPCS's decision, it has been decided that for 2016 there will not be any amendment to Annex II of the Basic Law. In other words, we can get on with the local legislation work. In fact, we have prepared a consultation paper regarding the 2016 legislative election. There will be a consultation on the traditional functional constituencies, the electoral base, how we're going to deal with this, and so on. For these traditional functional constituencies, if we were to broaden the electoral base, then it would be incorporated into the 2016 legislative amendments, or amendments for 2016 electoral election. And voter registration will be done, and we can do it in time for the 2016 legislative election. Mr. Zhong? What about the timetable? Let's say we can get the bill enacted. Are you going to have the registration done in the first half of 2016? Right, the 2016 legislative election will take place in September, and the deadline for registration will be something like May 2016. For FC electoral base, we have to amend the legislation before electoral rises for the summer in 2015, so that we can get on with the voter registration in time for the incorporation in the May 2016 register. Mr. Zhong, what about my first question? We have 600 more, but we have seen a decrease of 530. Can you tell us where we saw the decrease? What sector did we see the increase? Can you encourage more people to register themselves? Madam Ma? Chairman, the honourable member asked us which sectors saw a decrease in registration. Education saw a decrease, 1,900. Healthcare sector, down by 346. Textile and garment, down by 367. Catering, down by 1,382. These are the sectors that we saw decreases. The honourable member suggested that we encourage more voters to come forward and register themselves. In fact, in each cycle, we will write to the constituents, and hopefully they will incentivize more people to register themselves. Dr. N. Zheng. Chairman, thank you. Following on from Mrs. Regina Ip's question regarding how we can make it more convenient for people to vote, those who are working in the mainland. The Secretary told us that manpower is indeed a problem. I don't think this is a consideration, because if we really want to implement it, there must be a way. You talked about ordinarily resident. I am none the wiser. As long as someone is a permanent resident of Hong Kong, they should be entitled to vote. Would you have to consider someone being ordinarily resident in Hong Kong if someone is a permanent resident? Mr. Ching? Well, at least under the basic law, the permanent residents will have the right to vote, but under the electoral ordinance, other than being a permanent resident, one has to be over the age of 18. Someone has to be ordinarily resident in Hong Kong. This will determine the constituencies that they vote in, and also the connection they maintain with Hong Kong. Under the requirement, someone has to have a Hong Kong residential address for them to be considered to be put in a particular constituency. And for those who are working back and forth between Hong Kong and mainland, they maintain connection with Hong Kong. They're paying Hong Kong taxes. They may be working in the mainland or overseas on a temporary basis, but they do maintain a residential address in Hong Kong, and they maintain a connection. So when they travel back to Hong Kong, we would stick to the addresses that they file with us and decide on the constituencies that they vote in. Now, there is a demand that someone who spends an awful long time overseas, and they may not possibly be coming back to cast their vote, and it seems that they have been deprived of their voting right. Under the policy, someone can only cast their vote on the polling day. They have to come back and cast their vote in Hong Kong physically, and that's the policy consideration.
If we want to set up voting stations in every part of the world, there are resource implications, and also there is the question of fairness. We should not only set up polling stations in our mainland offices, because we'd like to do the same for offices in other parts of the world. There is also a policy consideration. If people have left Hong Kong a long time, they may have to register before in order to prove their connection to Hong Kong, so they are ordinarily resident in Hong Kong before they are qualified to vote. This is the main policy consideration. Chairman, if that's the case, then basically if he has an address in Hong Kong, then he is connected and he should be qualified to vote. PAS, you may be thinking about people in other parts of the world as well, but in fact, you should look at the mainland, and I'm not even talking about all places on the mainland, but let us take Beijing, for example. Can we try it for one or two spots in China, and maybe just for the mainland? I think we should not deprive those people of their voting rights. In bracket 04, para 8, some people will cease to be a registered voter if he is not ordinarily resident in Hong Kong. And then C, he is no longer a permanent resident of Hong Kong. Who are these people? I don't really understand 8C in bracket 4. Right now, the law stipulates that you must be a Hong Kong permanent resident before you can be registered. At the immigration department, well, not many cases are like that, but there are people who give up their ID cards. They return the ID cards to the immigration department, and these people are no longer permanent residents of Hong Kong, so they are not qualified to vote. But I have to say that there are just a handful of such cases. Mr. Ng Leung Sing. Thank you, Chairman. I have received such requests for assistance, and they're asking me to talk to the administration about this. There are really tens of thousands of Hong Kong people who have formed themselves into associations, and these people work on the mainland, but they come back to Hong Kong maybe once a week or even more frequently. However, they may not have the chance to vote. Their roots are in Hong Kong. They also make not meager economic contribution to Hong Kong because they work on the mainland, but then they support their families in Hong Kong. And in fact, they spend money in Hong Kong. Even if they shuttle between Hong Kong and the mainland, they actually contribute to Hong Kong more. And even those who work in listed companies, they are in this category. So I believe you should look at this again. We are talking about a big number of people. I hope you will be flexible and perhaps pick a few big places. And even if you talk about another country, if there are these people who always shuttle between Hong Kong and that place, and if they are quite homogeneous in a particular place, and I'm not only talking about the mainland, then you should help them by doing something. Mr. Felix Chung mentioned the functional constituencies. There may be some shifts among the traditional FCs, and now we have the District Council second FC, and people may be switching their registration between traditional FCs and this particular FC. And I believe some sectors are undergoing changes as well. But since we are going to have FCs and GCs, we need to encourage voters of both categories. So if there are sectors which are dwindling in size, maybe we should not waste resources on them, but other sectors may be growing. And when you do publicity, I hope you will look more carefully about the difference in sectors, and maybe you should provide more incentives. Last question. 2015 will be the year for you to concentrate on encouraging unregistered people to get registered as voters. District councils serve people in the districts. So if you want to promote registration of DC electors, the district councils should be given the responsibility as some powers to do it. Has the administration looked into this? When you start your work in May next year, can you not first talk to the DCs and then work through the 18 DCs to do your publicity? If the DCs have the power and responsibility to do this, would you also give them the resources, say through giving them a package of incentives and help, so they can help do registration on the district level? Mr. Zhang, thank you, Mr. Ng, for your 3 questions. On extraterritorial voting, I think we have already stated the Bureau's stance. I agree that we have to consider it for the long term. There is the issue of fairness, the counting of votes, and also manpower. How votes, for example, can be counted outside Hong Kong and be reported back. As for traditional FC elections and elector registration, maybe I can say a little more. In certain parts, there is a dwindling of numbers. This is because people have to be eligible to be voted in that sector before they can register as a traditional FC elector. Some people may be deployed out of their positions, or they have left the sector altogether, so they lose their eligibility. But that said, they will automatically have a second vote in the DC second FC. So we see people who are no longer registered in a traditional FC but are now an elector in the DC second FC. As for the next election cycle, which will cover the DC election, we are going to set up an interdepartmental working group where the HAD is represented. In fact, DCs work very closely with us in every election cycle. District councillors always get a lot of registration forms from the REO, and they help to encourage people to get registered when they meet the public. So they are a great help because they always help to encourage Kaifongs to get registered as voters. We should end the meeting by 4:30. There are 4 more members who would like to ask questions, and I would want to allow them all to ask questions. They are Claudia Mo, Raymond Chan, Sid Ho, and Priscilla Leung. Any more? If not, we'll draw a line there. Miss Claudia Mo. I'd like to ask about Hong Kong people who are eligible voters, but nevertheless who are outside Hong Kong. Well, I agree that we have to pay attention to fairness and also manpower implications. It seems some people are saying that those on the mainland should be given different treatment, that there should be a special arrangement for them. Well, I don't think so. Either you don't do it or you do it for the entire world. And then there are people saying we should only concentrate on places where there are gatherings of Hong Kong people. I believe you are talking about US, UK, some European countries, and then Canada, and also New Zealand and Australia. No, that won't do. If you are talking about a legal right, the legal right should apply to me wherever I am. If it applies to me when I'm in the UK, why wouldn't it apply to me if I am in a more remote place? Okay, that is only a comment. My question is, people who have eligibility but who are outside Hong Kong, so they are no longer ordinarily resident in Hong Kong, or who have lost their status as a permanent resident. My understanding is that you are just passive, is that right? You will not do active checking. Some people may study outside Hong Kong, they may read a doctorate, and they are no longer ordinarily resident in Hong Kong for a row of 7 years. But if they don't tell you, how would you know? You will only know if they declare. And as I said, very few people will give up the Hong Kong ID card, because you have the e-channels when you come back, and I think people love that convenience. And then there is another comment. I'd like to talk about the term permanent resident in Chinese. I don't think you need 5 characters. When you amend the law, perhaps you can do away with one of the characters in the term translating permanent resident. Okay, I'll take up this last question first. We cannot do it because it is also used in the basic law. Our laws are written according to the terms in the basic law. Ms. Mo also asked whether the information has to be voluntarily declared. This has to do with sample checking or verification by the REO. If someone is outside Hong Kong, we will try to locate him at the last known address, but if it's not found, then according to the present procedure, he will be included in the omissions list. And if this person cannot be contacted, then he will not be included in the voters register. And we will have to wait for him to let us know that he has a permanent residential address before he will be included again. The present sample checking or verification system will help us identify people who are not active electors. Next one, Mr. Raymond Chan. Thank you, Chairman. I welcome this OV's online voter information inquiry system. We can look up our own information, and in fact, we can also help the old people in our families to check their eligibility. My mother is in her 70s. She is in an aged home, but then she was involuntarily registered without her knowing. And then on election day, she was manipulated and she was taken to our polling stations to vote. I already complained against that. Now we'd like to disenfranchise her, or else next time she would be involuntarily activated again. I'd like to know if we want disqualification. Is it that we have to follow that particular exam timetable, and that is by the 5th of July 2015. But if I have disenfranchised my mother, but then she has been registered again using the address of the home of the aged, can I ask for disqualification for her any time? This is the first question. Second, the OVs will ask you for your name and ID card number, and then you answer 2 questions, and then you can see your own information, whether you are a member that can vote in a DC election, Legislative Council election, etc. But then I cannot check how many people have used the same flat for registration, because some people have found that 7 other people have used his own address to get registered, and he himself doesn't know it. So can this system be more flexible? Can you allow me to maybe input an address and let me know how many people have used that address to register? And I can then know that if I live alone and 10 people have used that address for registration, then I would get to know it. And can I really do that online, please? That's the second question. Thank you for those questions, Mr. Chan. Voter registration and voter disqualification, well, both can be done anytime throughout the year. It is just that there will be a deadline. In other words, by the deadline, if you have done something, then the registration or change will be reflected in the next final register. If you don't meet the deadline, then it is just that the latest information will not be reflected in that final register. Say if it is the 5th of July next year, which is the deadline, if I only disenfranchise my mother in September, then can she still vote in the November election? Or is it that she would be disqualified only in the next cycle?
Mr. Ching. The next cycle is the 2nd of July 2015. If a voter wants to take himself or herself off an electoral roll, then they should do so before the 2nd of July. Otherwise, the names will still be there. So I can choose to strike her off on that particular day or before that date. Right, on the second question, thank you very much, Mr. Chen, for praising the OVs that we just launched. A panel discussion, we were given to understand that it would be easier for the voters if the online system is in place. And this system is operational round the clock. During the discussion, there were concerns that if we can check the household information using just an individual's information, there may be privacy problems because they may not want that to happen. Alternatively, someone can turn up physically at the REO for the information, but the information is only shown to the checker, and nobody can copy anything, nobody can take any photo. Now, we believe that this would be a better arrangement to protect the privacy. We liaised with the Privacy Commission, and this is a better arrangement. So I can check how many voters there are at my registered address. Yes, if you turn up at the REO, yes. I don't think there are any problems with privacy if you make available the information online. Yes, we can consider that. Now, whether the number of registered voters would be or should be made available, I think it's open to interpretation. There were some cases in which the old folks' homes would be registering the voters, and the number would be very large. It's not a question of many households registered the same address. It's just registered home for the elderly. Well, can I check the home for the elderly? If you have the registered address, you can get access to the information. Right, let me add. You talked about taking someone off the electoral roll. Does someone have to write in? Or can someone call up to do so? No, you can't just call up because we have to verify the information. At the present moment, there is a form one can fill in if you send a letter, and then there will be followed up by the REO. But you cannot take the name off on behalf of somebody else, can you? The voters themselves will have to submit the information like the ID card number, and he has to sign on the dotted line before this will be followed up. So the voters themselves have to say that they don't want to be a voter themselves. No family members can do this on their behalf. Correct. Ms. Sitho? Chairman, thank you. Two sets of statistics. Paragraph 3, 2014, 77,000 newly registered voters at the GCs. Paragraph 9, for DC's 69,400 newly registered voters. The two figures do not seem to tally. Is it true that some of them are from the traditional functional constituencies? We're talking about 8,000 or so. Are they all from the traditional FCs? Is it the case that they don't know that they can also register themselves at the DC second functional constituencies? Nobody reminded them, and hence the discrepancy. Now, for these 77,000 newly registered voters, how many of them are between 18 and 20? How many of them are newly qualified as voters? And this will show us how passionate the young people are about voting. Also, for functional constituencies, now everybody can be part of the DC second FC. They can also return to the traditional functional constituencies. Are there many situations of people switching back and forth? If someone wants to switch over, how long before the polling day does one have to act before this will be possible? Normally, in May, you will have the register. Mr. Ching, I leave the statistics to the REO. Perhaps I take the second question first. For the traditional functional constituencies and the DC second FC, indeed, there may be some who would register with the traditional FC, or some stay with the DC second FC. Some may cease to be eligible or for the traditional FC, and they will switch over to the DC second FC. Some may be switching back to the traditional FC. So these figures are rather dynamic. Some choose not to register with the DC second FC. We do have the opt-out system, so there is switching back and forth. For the deadline, we follow the normal registration deadline. So someone has to decide which way they want us to be registered with before the deadline. It's up to voters to decide where they want to register themselves, as long as they do so before the deadline, and they will be reflected in the latest electoral roll. Right. Last speaker, Sid Ho. My question remains unanswered. The young people registration for the young people and para 3 and 9. 69 for 1,400 and 77,000. Can you explain the discrepancy? Right. About Ms. Ho's question, Ms. Ching has already answered the question. With regard to the figures, some voters choose not to register themselves with the DC second FC. Some register themselves with the traditional FC. So that explains the discrepancy. Regarding young people, we don't have the figures. Regarding young people between 18 and 25, for those who register themselves when they get the ID card, we have a figure of 29,000. So 77,000 versus 29,000. There are 40,000 that belong to other age brackets. Will you give us the age profile of the newly registered voters in writing? If you have the information now, so much the better. Yes, indeed, we'll have a look. Chairman, about the age profile, it is included in the appendix. We do provide age profile. I'm talking about the newly registered voters. Yes, we're prepared to give the information in writing. Last speaker, Ms. Priscilla Leung. Chairman, on the question of voter registration, I'm offering my comments only. Now, if you say that you will continue to look into this, this is not good enough reply. I don't support any voting by overseas residents. If they are prepared to come back and cast a vote, it would be more reasonable. Since 2001, there are people who have lost their registration. And there were talks about voter rigging. Now, even the inmates are entitled to votes. What about those elderly people who are residing in the mainland, who are working in the mainland? It's not reasonable for them to lose their voting rights. Senior citizens are entitled to their fruit money. Now, there is a question of how we can help the elderly people to take themselves off the electoral roll. I don't think it's a good idea. We have to protect the elderly people. In this Occupy movement, we see that there is a rift even within the family members over the same issue. If we want to remove the elderly people from the register, it may not be a good idea because their voting rights should be protected. I don't think the family members and the third party should be given this right. It's like writing a will. We have to have a third party. This is a right on the part of the elderly people. This should not be deprived of so easily. Hong Kong is really indeed torn apart. We have to respect the elderly people, whatever age they are. Random checking is not good enough. We talked about this from 2012. There may be a lot of names registered to the same address. There should be investigation instead of just random checking. We have to make sure the people will maintain or keep their voting rights. You have to remind them of the irregularities or the pitfalls if they are innocent. I think there has to be physical checking at these residential addresses. Some are cohabitating. They don't really want people to know about it. You should turn up and physically check them. It's no good for you to disclose all the information online. It would be far better to disclose the information on the web. For those who haven't lost the permanent residency in Hong Kong, they have paid tax in Hong Kong, and they have the connection with Hong Kong. And there are many Hong Kong people who are gathering in certain places in the mainland. You have to make the arrangement for them to understand how they will not lose their voting rights. The voting rights are important. Just because they're old doesn't mean that their voting rights should be deprived of by their kids. Just because they are in the mainland, for financial reason, for work reason, they may be traveling back and forth. They don't have residential address in Hong Kong. Doesn't mean that their voting rights should be deprived of. I have received assistance or requests for assistance. We are arranging for the inmates to vote. Why do you deprive these people of their voting rights? I think the government is evading the issue. It's no good for you to say to look into this continuously. You have to tell us in no uncertain terms what measures there are to help them. I would appreciate a reasonable reply. I've got 20 seconds left. Mr. Cheng? Yes, indeed. We're aware of Ms. Leung's request. Ordinarily resident, this will be based on facts. If someone can provide us with a residential address in Hong Kong, we can make the arrangement for registration. But this has to be a genuine address. Ms. Leung, you should go and tell people about it. People are really scared. They want to vote. There is nothing to do with vote rigging. Now you're telling us that they have to have an address, or even a relative's address. Then they will enjoy the right to vote because they are permanent residents. Mr. Ching? Well, let me say this. They have to prove that they are ordinarily resident in Hong Kong. It would depend on individual cases. Someone may have left Hong Kong for a long time, and they may not intend to come back to Hong Kong. It is different from someone living or residing in the mainland. Right? Children should not be allowed the right to deprive their parents of the voting right. Indeed, Mr. Summer already said that the voters themselves will have to sign on the dotted line before they can strike themselves off. So, well, I'm concerned about the elderly people being harassed. Maybe the children would like to support a particular candidate, and the elderly parents would see otherwise, and they would have the name struck off the list themselves. I think we have to respect one another. This is all about Hong Kong's values, right? This is time for us to bring it to the close. Any AOB items? No? Meeting adjourned.